So this paper is on what we might call administrative governance rather than corporate governance. It's an early draft, so I didn't want to post it for public accessibility on the internet, but I'd be delighted, anyone wants a copy, I'd be delighted to send it to you, and comments are most welcome. So let me just start with the paper in a nutshell. So what I'm looking at is whether agency governance affects agency decision-making. And so the hypothesis more specifically is whether the more independent or insulated an agency is from political control, is it less likely to use politically accountable rulemaking. I'll explain what I mean by this shortly. But I'm going to compare then the activity of the Consumer Financial Protection Bureau that has a uniquely independent design with that of 3 other independent agencies that have similar missions to the CFPB, but are more conventionally structured. To say my fairly robust result is the empirical analysis is going to find that the most politically insulated agency, that is the CFPB, uses notice and comment rulemaking, which, as I also mentioned, is the most politically accountable form of agency action, far less than the others, significantly less frequently. And the main implication, I'll talk about a couple, but the main one I would say is that if Congress intends for agencies to use notice and comment rulemaking, that's the core of the Administrative Procedure Act, and to follow also statutory instructions that it provides agencies with respect to that rulemaking that it wants them to take into account, then when it designs an agency, it should rely on, I'm going to argue, the more well-established commission structure from this data. So legislation to reorganize the CFPB along conventional agency lines would be salutary in bringing it into the realm of political accountability to the extent that we think that's a good thing for an agency. Let me just start with a very brief primer on administrative law background for the US for informal rulemaking. So the first thing is I'm working out of the positive political theory, the PPT literature, that talks about how Congress attempts to control agencies by specifying procedures and providing litigation rights for constituents to police them. And this is a classic paper by McCubbins, Nolan, Weingast. And I'm combining in my paper 2 sort of prongs of this empirical literature in PPT. One is that the form of an agency, that Congress designs the agency so that it can have control. We could have executive branch agencies versus independent commissions. And the view in this literature, as it's discussed, and there's some empirical data too, is that Congress exercises more control on an independent commission and takes that away from executive branch or presidential control compared to cabinet departments. And I want to combine that sort of idea with McNoll-Gast's, so that's how they call themselves, McNoll-Gast's view that actually one of their sort of contributions was to say, well, it's not just the agency structure, but what's really important is it structures the procedures agency follows to get them to be responsive to Congress in ways that sort of, as I mentioned, this might become clear. Informal rulemaking is a technical term of art that most of us would not think is informal, but it refers to the following the notice and comment requirements laid out in the Administrative Procedure Act. But they also have statutory exemptions of when agencies don't have to follow those requirements. The main one is guidance, policy statements. Those are referred to as non-legislative or interpretive rules. So notice and comment rules or informal rulemaking is referred to legislative rules. But there's also an exemption for legislative rules. If agencies find for good cause, it doesn't have to follow that process. And I'm going to be dividing then the types of actions between the notice and comment rules, then these exempt rules and guidance. And one key thing is the Administrative Procedure Act gives parties that are aggrieved by agency action the right to have judicial review of the action in court. But guidance is not considered final agency action. So therefore, the APA does not give them the right, give a party aggrieved by guidance the right to get judicial review of that action. And these are going to be part of what I'm teeing up in this paper. So let me just briefly refer to the research design. So what I'm going to be doing is comparing the decision-making of the CFPB in its initial years of operation. So it was created by the Dodd-Frank Act. So I'm looking at the first 5.5 years of what it did. And I'm going to compare it to a set of other subsample of agencies. So the first comparison, my analysis I'm going to cover here is not going to be separate for these, is the Consumer Product Safety Commission. That was sort of, when Liz Warren wrote her paper, actually that was the agency she had in mind when she was arguing that we should have an agency that regulates, a separate agency for consumer financial products. So she's comparing to the physical products that the CPSC studies. So I'm going to compare it to that. In its initial years of operation, it was created in the mid-70s. So this is going to sort of an idea of controlling for agency life cycle, that maybe agencies at the start of when they're created have to do different kinds of rulemaking or agency action than later on. I'm also going to compare it not just to the CFPB. So that's going to look at the first 5.5 years of the CPSC compared to the CFPB. But there's like 20-odd years. There's several decades in between. So agency practices can change over time. And there are also some changes to the CPSC had a unique public participation requirements at the outset that were repealed in the 80s. So I'm also going to look at the CPSC action in the same years that I'm looking at the CFPB. Then I'm also going to compare it to the SEC and the CFTC. So here we've got financial products, although they obviously have broader regulation and not just for retail, but they do have that context. And we're looking at the same sort of 2011 to 2016, and they, like the CFPB, have a lot of action under the Dodd-Frank Act that they had to comply with or adopt procedures or rules or guidance for. And so that's going to control both for the products and the regulatory climate, that is the demands that Dodd-Frank placed on the agencies. And I should note one sort of common thing across these agencies is they're basically product gatekeepers and regulatory supervisors. And so they exercise a lot more control over regulated agencies, entities than some other types of regulation might be. That is that, if you're not complying with what they want you to do, they can put you out of business. And so guidance in this context is more likely to function as a rule type of thing that companies think they have to comply with than in some other contexts. Let me note about agency independence, right? So this is what I'm obviously studying. So Datla and Reves identify 7 criteria of agency independence. So there's a lot of studies where they just try to look at one thing. Are they an independent commission with fixed terms and removal protection for the head of the agencies? Barco adds whether they have review by the Office of OIRA, which is a subset of the OMB. So these are government, executive branch agencies that look at what you do. As they point out in Datla and Reves, that there's actually variety among these agencies that some people would call all independent. So they're more granular, and they have 7 characteristics. And so the agencies in my study share 4 of the 7. Briefly, they diverge on 3. Really, one is a subset of another. They diverge on whether there's a specific statutory removal restriction and whether it's a multi-member structure with a second feature is if you have a multi-member structure, partisan balance. That means these statutes will say that you can't have more than 3 out of the 5 commissioners to be from one political party or the other. And so the idea here is that if I isolate which characteristics the CFPB does not share with the others, and I'm going to find a difference in its action, then I'm identifying the source of the independence. So I can get more which is the factor. And so actually most people study securities law, we typically would think that the commissioners actually have removal protection. Right, so by removal protection, we mean is that the president can only remove you for cause, whether it's misconduct or negligence or inefficiency. That's a piece in the CFPB statute. And there's actually no explicit removal protection for SEC commissioners or CFTC commissioners, which most people would think they do. But there have been court decisions, including a Supreme Court decision, that implied removal protection for commissioners at the SEC and these agencies. So it's less important of a difference. And Datla and Reves also point out that there's certain little statutory language that may differ. So the CFPB has like 3 things of removal: inefficiency, negligence, and misconduct. The CPSC doesn't have inefficiency. But apparently, if you look at all the cases and stuff, there's no difference that's ever recorded in any practical matter, differences in the language. So they treat them all as the same. The main difference that between the CFPB and the others is it's not a multi-member commission. So it's led by a single director. It's located in the Federal Reserve System. The director serves a fixed 5-year term with removal solely for cause. Federal government, though it's in the Fed, Federal Reserve governors may not intervene in its affairs, very broad grant of authority. And so if we're looking at sort of the Datla and Reves features, that's what distinguishes it from the SEC, the CFTC, and the CPSC. They are all multi-member commission agencies with fixed terms and partisan balance requirement. Another key difference that is not really in the DATLA and REVES decision criteria has to do with the financing, although they do have a related criteria, that is whether or not the agency's budget has to be reviewed by the executive branch or can go directly to Congress, so more congressional control than executive control. But the big difference between the CFPB and the other agencies in my comparisons has to do with the appropriation process. It's not subject to going through congressional appropriations. The statute gives it, the director has its own discretion to set his own budget, and as long as it's less than 12% of the revenues that the Federal Reserve has, that's what he gets. If he wanted more than 12%, then he would have to actually seek money from Congress. They've never gone above 12%, and whatever fees they collect in their 6 years of operation. So they're basically not subject to appropriations, as are the other agencies that I'm looking at. And we should note this is very sort of pretty atypical. There are other agencies of the federal government that are not subject to the appropriations process. They tend to be multi-commission structures. So the one that isn't is the Office of the Controller of the Currency, the OCC. The head of the OCC does not have removal restrictions. The president can get rid of him. And they also, though, tend to have more narrow technical missions, so they're prudential regulators. And so one might think that that mitigates sort of, if we're worried about Congress doesn't have control over an entity because it's not appropriating funds to it, so it can't say, if you don't do what I want, I'm going to take away your funds, I'm going to put a rider on you and the like. Well, if there's less of a broad jurisdictional basis for what the agency can do, then you've got some control over it, even if you're giving them, you're not going to appropriate. So there is this difference between it and the other agencies. So it's sort of uniquely independent compared to at least the three other ones that I'm looking at are all subject to appropriations, and they have this, the multi-member is the big difference from these 7 characteristics. So let me talk a little bit about my data set. So what I did is I collected all the rulemaking and guidance activity of these 4 agencies, and as I mentioned, I'm looking at the initiation of the CFPB. The CFPB, that's the first actions that it took in April. It was not able to adopt rules for non-banking entities, so it has a jurisdiction not just of banks but others, until a director was formally appointed and qualified for his position. That was in within my period. I've also looked at it for after the director was appointed. It has no difference, so I'm going to use my full period in talking about this. The CPSC, I've also got the period in which the same number of months for its initial years. And I've excluded enforcement actions in part because it's very difficult. You know, you've got thousands of enforcement actions. And what I'm trying to get at is actions that could be like policy making that I'm doing outside of the rulemaking process. And that's not a lot of enforcement. And also, enforcement actions are often, when they're policy related, and I'm going to give some examples later on, they're related to also guidance being put out. And so if I'm capturing all the guidance, then at least to that extent, I'm going to be also capturing the enforcement. So anyway, I'm going to look at all this data. My statistical analysis is going to exclude insignificant activity. So I start out with, for these 4 agencies over these time periods, with 915 actions. That's rules that are either by notice and comment, by exempt from notice and comments. They're called like interim final rules or final direct rules. They have a variety of names. And guidance activities can be called policy statements, interpretive release. The agencies have different names for things that are essentially the same, but they're the same legal import. So I'm going to group them all together. And then I'm going to get rid of things that are insignificant. These are things like a technical correction. So if an agency finds there was a spelling mistake or a grammar mistake, it issues a new rule. It's called a technical correction or a technical amendment, but that would be in my 900 count, and those are things that are trivial and unimportant. So if one agency has more typos than another, I could get biased results. So I'm going to get rid of them, and I'm trying to get only all notice and comment substantive rules, and the same with a policy. The SEC has Edgar manuals, and there's a bunch of them that they update every couple of months, something that you're putting in your Edgar manual for guidance. So I'm going to get rid of insignificant ones. So my data set is 562 total actions. All right. So let me just give you 2 pictures about what's going on. Right? So this is just looking at absolute numbers of the form of agency policymaking, notice and comment versus rules that didn't go through that versus guidance. And you can see right away in the numbers, the CFPB, so the lighter color, I gotta hold this thing so I can't hold 2 things at once, can I? If I could find the pointer, I would, okay, here it is. The lighter color, right, is the notice and comment. And as a percentage of like guidance, which is the darker color, the CFPB is clearly sort of less, right, notice and comment than any of the other agencies. Or if you want to look at it visually by percentage of activity that's notice and comment, again, so the darker one is notice and comment. Whoops. I can see why the other person had this problem with this hitting this thing. We're using page down here. This one? Okay, so so this is a percentage of notice and comment of all of the activities, right, so of that agency within my 562, right? So you can see the CFPBs is less. Whatever I look at it as notice and comment of all things that have comments. So some agencies ask for comments on guidance, or in their rules that they've adopted, these interim final rules. After I've adopted the rule, I could solicit guidance after the fact and say, okay, you can send me your comments. Solicit comments after the fact. Now, unlike a notice and comment rulemaking, in those cases when I get comments, in adopting my final rule, I've got to give some reasons or explanation of why I'm ignoring the comments or accepting them. That's part of the sort of the statutory requirement and how the courts have elaborated what you're required to do. When I'm getting comments in this other context, in a non-notice and comment proceeding, I can just ignore them, right? And so, but this is just looking, I can do it again, right? Right? If we're just looking at sort of then other things that have comments, still the CFPB has fewer getting comments on other things as a percentage of notice and comment. Here's just guidance. The CFPB never asked in this period for guidance, for comments on a guidance compared to the other agencies. So just visually, we're going to see what a multivariate analysis is going to actually show. My variable definitions, my dependent variable is then going to be a 1. So my observations are the actions by the agency. So just a dummy variable, 1 if it's a notice and comment rule, 0 if it's something else. My agency are going to be 1 if it's the CFPB and 0 if it's the others. I do a bunch of multiple univariate comparisons of notice and comment, cross tabulations, notice and comment by agencies. And there's no difference. There's a difference between the CFPB and everything else, but there's no difference across the other agencies. So for my statistical, multivariate, I'm going to group them. And I've just got a couple of variables I'm using. One is Dodd-Frank, just in case, Dodd-Frank, maybe you had to do more rulemaking for it. Or it had some different effects. So if the action referenced the provision in Dodd-Frank, then it's Dodd-Frank, so that's going to be a dummy variable. And then I'm going to have year, so that some literature has found a time trend that over time agencies have issued, looking at they're really different years than I've got because they're older papers, but would find over time agencies have issued fewer notice and comment rules. And then there's also some view that when you have divided government versus unified government, you might get different rulemaking that some people have found. So I'm going to be controlling for these as well. I should notice, that notice and comment, there's a trade-off in using it. So it has more accountability. It's sort of this key point of McCubbins et al. Because from their view, right, is we get more information. So if we think about sort of the literature, we're thinking about this as a principal agent problem between Congress and the agency, and getting the agency to do what we want or what the constituents that we favored in the statute want. Well, we need information, but the agency has more information than us. So we've got to get that information. Notice and comment gets us some information because they have to explain what they've done. And the constituents, like if they don't like what they've done, they go to court. So that's like, this is the fire alarm versus the police patrol sort of view of Congress that gives us information that they're doing things we don't like. So it's accountable, it's more transparent. On the other hand, it takes longer, and there's less flexibility for the agency because in guidance we can change our minds. So there is this trade-off between them. But that's sort of the rulemaking that I'm looking at. I'm going to sort of skip for time my table and just sort of give a summary of my findings. So as I said, these cross tabulations show that CFPB is different from everybody else. They're not different from each other. So my multivariate analysis just combines the other agencies. And we find that the CFPB is significantly less likely to use notice and comment rulemaking. So these are logic regressions. So if I look at a log odds ratio for this, a regulatory action is 19% less likely to be handled by a notice and comment rulemaking if the agency is the CFPB. It's more likely to be notice and comment if it was Dodd-Frank, 7 times more likely to do that. But the CFPB here is no different from the other agencies in Dodd-Frank. And it also has fewer deadlines. So if we thought the reason why it had less notice and comment in general was because it had a lot more deadlines, and so it has to do a lot of things, and it takes a long time, that's not the case. The SEC had more deadlines to meet. Of course, most of these agencies didn't meet the deadlines, but it had more to meet than the CFPB, and it still did more notice and comment than that. the year variables, and then separately when I look at political environment, whether the government was, we have in some period the Democrats controlled Congress with President Obama, then the Republicans, got control of both houses, and the CPSC in its initial years was the reverse, right? That they're not important, and so the findings are consistent with the view that agency governance affects the instrument an agency adopts for policy making, and that could facilitate an agency sidestepping congressional directives regarding its decision making. So we have to say, well, why does it matter? Why should we care if it doesn't do notice and comment? So you should note that Congress specified particular considerations the agency is supposed to use if it's doing informal rulemaking, and that's basically a cost-benefit standard, right? So if I'm not using notice and comment, I don't have to meet that standard, right? It's only the statute specific about notice and comment. It could also avoid judicial constraints because, as I mentioned, right, the courts typically they defer to the agency in the type of action that it takes. So they don't say you had to do this by A versus B. And then, as I said, you can't. If you have a guidance, a person can only be aggrieved if it was enforced against them, right? Because guidance, as I said, is not final action. Regulated entities like banks tend to not litigate the enforcement actions. They settle. And a study of the CFPB's enforcement actions found no bank ever sort of litigated. So they're all settled, so you're not going to be able to bring enforcement action. So it can avoid judicial scrutiny plus executive or congressional scrutiny by doing this. Of course, this analysis does not show anything about whether they're using it strategically, right, at all. So I have some illustrations about this, and let me just mention one, because it's the most flagrant. There's been a lot of press on this. So the statute excluded from the CFPB's jurisdiction automobile dealers. And loans for cars are a big financial product that consumers have. So they're just an important, powerful lobby. But they were excluded, right? So the agency decided it wanted to regulate them. I thought they were discriminating against. So the only way it could do it is indirectly by affecting the banks that buy the loans, because the banks are subject to their jurisdiction. And they did this by guidance. Now, there was an investigation into this, and internal documents that were revealed in a congressional investigation found that the agency staff actually discussed, should we do this as a notice and comment proceeding? And they said, well, if we do this, we don't really have legal authority to do this as a rule. We don't have authority over automobile dealers, and some other issues came up. And so therefore, and will be challenged in court. So therefore they said, we probably shouldn't do it that way, and they didn't. Right? So, so it's not, I'm not saying all actions that use guidance are strategic and that all other agencies don't, but there is some evidence here. So let me sort of conclude with talking a little bit about the implications. As I said, the tables are here if anyone wants to see them in Q&A. So the implications are, A, agency design affects choice of regulatory instrument. There's been some people, a comment in the NYU's book on Dodd-Frank and some blogs and the like that have said, the CFPB is doing fine, we don't need to change anything about it, because it's only issued a very small number of rules that all seem good through the deliberate process. And that's sort of an incorrect statement, because it's missing the legal landscape that basically most of their actions have been undertaken not through notice and comment rulemaking. So as I already mentioned, that if Congress is really serious, now maybe it's not serious, but if it was serious about wanting sort of when it set up the APA, right, which was to change from the original sort of way the agencies acted, the formal adjudication process, right, where you had you had like almost a court-like setting to do a rule. Well, if it's serious about wanting notice and comment to be the main form of rulemaking, and they want you to follow these things when they put in the statute, like saying cost-benefit analysis, then it should be thinking more about the design. And I'd argue sort of since the conventional agencies seem to be using it more frequently, right, all other things controlled for than this more independent agency, that might make more sense. Because that structure gives Congress at least more tools to obtain information and exercise oversight and its control over the agency to do what it wants. And to just sort of conclude, though, it's not that I'm arguing that the use of guidance is always strategic, or that other agencies don't engage in strategic activity, or even that there's an optimal level of notice and comment rulemaking, right? But rather that on the margin, a more insulated agency is less likely, it appears from my data, to use the more politically accountable regulatory instrument. So if we're thinking about democratic accountability, right, from that perspective, what we want from agencies, it would be desirable for the CFPB's use to mirror more closely other agencies. And so the current sort of view about trying to revise its structure is something that might be salutary.
So thank you, Roberta. And now we'll have Holger Smallman providing the discussion.
Well, thank you for having me. Thank you, Roberta, for an interesting paper. I'm going to summarize the paper just very briefly and then have 2 comments to make. The question that Roberta asked in this paper is a very important one, which is, do regulatory agencies with greater independence regulate less accountably? That has come to the fore, I think, particularly with the Consumer Financial Protection Bureau, which has been controversial from the start, and as you may know, is right now under Republican attack in Congress. And Roberta uses this and operationalizes this question for empirical analysis, where she statistically compares rulemaking, or I should say, regulatory actions taken by the Consumer Financial Protection Bureau, which is a single fixed-term director agency that sets its own budget, with actions taken by the SEC, CFTC, and the CPSC, which are bipartisan commissions that are subject to appropriation legislation every year, and of course that means that every year they can be reviewed by Congress and they can be beat down if they did something that Congress didn't like. What Roberta analyzes is, how do these 2 groups, or this one agency versus the other 3, how do they differ in their respective use of informal, bad word in this context, guidance, which means it's not technically a legally binding document, at least not binding on the regulated actors, but it has certain legal implications, versus notice and comment rulemaking. And since not everybody here is a lawyer, certainly not everybody is an American lawyer, let me say something about notice and comment rulemaking. What does that look like? Well, that looks like the agency puts out a proposed rule and opens it for comments for 60 days. During those 60 days, depending on the subject matter, hundreds, perhaps thousands of comments can be submitted. Certainly the industry and their law firms and so on commit these comments, and the agency is under an obligation to respond to these comments in their final rule release. And then the final rule can be, of course, challenged in court, scrutinized in courts, and at least in the practice of the courts today, especially in the DC Circuit, the court looks very closely at what the agency has done and whether it has indeed responded to all of these comments. So the threshold there for the agency is quite high, and of course, as Roberta lays out in her paper, it's an information forcing device as well, which can give Congress ammunition later if they want to intervene in some way. The answer that Roberta then gives to this big question that I laid out in the beginning is that yes, the CFPB, which is the more independent agency among those 4, uses guidance much more often, and that's not accounted for by certain control variables. And I think the most important one being Dodd-Frank, because Dodd-Frank just imposed a mandate on 3 of those 4 agencies to make a lot of rules and to make them fast and to make them with notice and comment. But that, Roberta is taking that out in her tests. All right, and so basically this graph tells you almost everything you need to know, minus the control variables. It just shows you that the CFPB, firstly, they make the most use of guidance in general, but most importantly, they, relative to the notice and comment rulemaking, they have a lot more of it than the other 4 agencies. All right. So perhaps my main comment, I have 2 comments really. My main comment is on what this paper tells us about those 4 agencies and what it tells us about types of agencies. This is like about the sample and about the population of agencies. So I think the paper establishes quite clearly what that graph already strongly suggested, which is that the CFPB differs from these other 3 agencies when it comes to the use of guidance versus notice and comment rulemaking. But the actual question asked, I think in the paper and the presentation, ultimately the question that we care about if we are not just interested in the CFPB is the general question: do very independent agencies act differently from just independent agencies? Because of course the SEC and the CFTC and so on, they are also independent. They're just not quite as independent as the Consumer Financial Protection Bureau. And of course, the problem with that is, for that question, we have an N of 4. There are 4 agencies in this sample, and they may have all sorts of idiosyncrasies that explain things. And it doesn't matter how many individual rulemakings we have only 4 agencies, so the N is 4, and the non-parametric p-value for any result that we can find is 1/2. So statistically speaking, we're not going to get very far, and also because, of course, the study, I take it, is inspired by the CFPB. This is, if we're testing a general theory, we're testing it on the same data that inspired the study in the first place. And so statistically, that's not a valid way to do it. And my conclusion is then that statistics alone cannot answer this question. And I'll have some suggestions about just what the framing mostly and what to do about it. I did that too quickly. I wanted to prepare the ground for this. Dare I say it? Dare I say it? Perhaps a more qualitative framing of the exercise, not throwing away the data, which are obviously interesting, but embedding it in a more qualitative study and perhaps looking a little bit more closely at many of the rulemakings that have been going on and the use of guidance, not just by the CFPB, which is in the paper. There are 3 little examples, but doing this more broadly for some of the other agencies and along dimensions that I'm going to get to. Just to amplify a little bit on this point that there's an N of 4 and that there may just be all sorts of things going on. So this is sometimes in logic, you can very well sometimes conclude from 4 observations, well, if you really account for all the possible reasons why something might be one way, well then, once you've sorted through all the possible reasons, you've determined the one reason why this one particular observation is different because, there's no noise, okay? But this is not a setting where there's no noise. There's just a couple of things that I think I mentioned in the paper, but that the regression cannot control for. Those are things like the CFPB, I think, was founded in a more political acrimonious climate than any other agency. I mean, I don't know any other agency, but certainly than the other 3 agencies. There's one agency in the sample, the CPSC, which you have data from the founding years, but those founding years, that was in the 60s, if I remember correct, or 70s. In any event, it was a different political climate, and so while it's definitely helpful to look at the beginning of that agency, it's not clear that that can really sort out this question. Maybe there's just something about the environment in which the CFPB is operating right now. Then there are differences in statutory mandates and powers, I'll get to that, and even something like a director of fixed effect. We've had one director of the CFPB. Maybe the next one is going to act differently. So, I mean, I'm not saying none of these is as usual with statistical noise. I'm not sure that any of this matters, but if we're going to draw conclusions from, just in a statistical sense, from the sample, those are all in the noise term, and with 4 observations, we can't really rule out any of this. So, let me say a bit more about one particular point where I'm really curious what one would find if one dug a little bit deeper, and probably not in a statistical way because the coding and so on would be very hard, but more like a case study. In the paper and the presentation, I think the guidance and notice and comment rulemaking are seen as more or less the same thing. So from the perspective of the regulated entities, whether the agency does a notice and comment or just gives guidance is the same thing. And I will grant that there are definitely circumstances where that may be the right way to look at it from the perspective of the regulated entity. But I think there are some side conditions there that are unstated and that are important to bring out, and perhaps that's the kind of thing one might look at if one dug a little bit deeper at these individual actions that are being taken. So it is true that if the agency has power to enforce a self-executing statute, and the agency's interpretation is sufficiently plausible to withstand scrutiny in court, and the sanctions are sufficiently high that if the courts agreed it would be ruinous for the regulated entities, then with those 3 conditions, regulating by guidance is as powerful as by rule. Why? Because once the agency puts out the guidance, no sane regulated firm is going to go against what the agency has said. Because if you do, you're going to be challenged, and you make a calculation that the expected loss from the sanctions is so high that it's just not worth trying this out. So sufficient here has to be understood in the terms of cost-benefit calculation of the regulated firm. But those are fairly strong conditions. In particular, number one, for example, oftentimes statutes do not give an agency the right to enforce anything until they've actually written a rule. I mean, Section 10b of the Securities and Exchange Act, for example, is an example. Without a rule, the SEC couldn't do anything. I'm not an administrative lawyer. I don't know what the distribution is in these agencies, but it's something that I would very much like to know, because of course these items there, 1 and 3 in particular, they can differ quite strongly by agency, or I should be more precise, by the particular actions that the agencies are generally empowered to do, like their jurisdiction. They get specific grants of powers of what they are allowed to do, and sometimes they get the power to enforce a loose standard against regulated entities directly. Sometimes they only get the power to enact a rule and then enforce that rule. So that all differs, and of course that might very well differ between these 4 agencies. I think it would be very difficult to get a firm statistical sense about how they differ. Not impossible, but it would be interesting, I think, at least as a, get a qualitative sense of what's going on with these agencies. There's another thing, and that's how do we interpret the use of guidance? Because if those 3 things are true, where the guidance is essentially the same as a rule from the perspective of the firm, then it's not clear to me that the guidance is really something that is restrictive of the firms. Now, if it's actually true that the agency has the power to go after firms even without making a formal rule, and what they want to push, the position that they want to push, is sufficiently reasonable that the regulated entities are sufficiently afraid that the courts will actually accept that position, and then there will be a high sanction. In that sort of scenario, the guidance actually helps the regulated firm. This is arguably a deregulatory act. Why? Because without the guidance, the agency could already go after the firm. And we have, again, I'm not a regulatory lawyer, but I am a corporate lawyer. And so, for example, the SEC has from the outset, in insider trading cases, been pushing a very hard line on what constitutes insider trading. And they have done that not because they've passed a guidance that would have said that, they just brought enforcement actions. And if these conditions are true, then that's what they can actually do. Now, the only reason for them to pass a guidance, there's 2 reasons. One is they actually they announce that they're going to do this. They want to get, to get the firms to do this proactively. And they have an alternative. They could just start bringing enforcement actions. If they did start bringing enforcement actions and then settled them, we might get a very similar result. So it's not clear to me that guidance here has this freedom restricting effect that I think the paper implicitly assumes that they have. Again, this is against the background. I'm thinking perhaps too much like an economic theorist here, but if there's no power by the agency to do anything bad to the firms in the absence of a rule, then the guidance is useless. So there must be that power, and if there is that power, then the guidance, I think, mostly binds the agency's hands. I realize that the real world is a bit more complicated. So, for example, you might think that an agency doesn't actually have the guts to go and bring an enforcement action unless they have previously announced this, or you might think that the very fact of doing that, going after firms without having given guidance, is something that would somehow upset Congress, and hence you have to do this. It definitely does change one thing. I think the most important difference is that if the agency adopts a rule first, that provides an opportunity for a regulated entity to bring a lawsuit directly against the rule. It has standing to do that. Whereas if there's just the guidance, then it presumably does not have standing to bring an action. I'm not quite sure. I could imagine getting declaratory relief. I don't know if the courts do that. But so this question of standing for lawsuits, that's an important one. In any event. I realize that point one is a little bit controversial, but I also realize that the position that guidance and notice and comment rulemaking is also controversial. I've looked in literature a little bit, so not everybody agrees that those things are essentially the same thing. And there's another difference between guidance and notice and comment rulemaking, which is that if the agency actually does use notice and comment rulemaking, then its adopted rule is going to get deference by the court, or at least that's what the courts say, whereas if the agency just adopts guidance, that is going to get much less deference. Now, I'm a very big skeptic of whether those standards of review, these deference things in administrative law, actually make a difference. I think they're just excuses for the court, or rhetoric devices for the courts to strike down or not strike down certain things. But at least in the official doctrine, it does matter, which means that if an agency is confronted with a choice between a notice and comment rulemaking and guidance, well, one thing they might be thinking about is the story of the paper. And the story of the paper is, well, if they can get away with it and they can just whack the industry without scrutiny, they're going to use guidance. Another way to think about it is, there's a resource constraint in these agencies. They want to do stuff. Notice and comment rulemaking is extremely labor and time intensive because you have to, first, you have to do all that. You have to give the 60 days notice and comment period, and then you have to react to all the comments. But also, just the people you need to review these things and then write this down, it takes a very, very long time. If you do it, you get more deference, but it takes a long time. So there's a trade-off, and you might choose to use guidance where you know you won't get as much deference, but you can do it extremely fast. And I just like to see more of a discussion in the paper about these trade-offs, perhaps with examples from what not just the CFPB, but all of the agencies have done. All right, so the upshot of my comments really, it's just two. One is that from a statistical perspective, we can't really infer anything from 4 observations for the universe of agencies, because the sample is too small, and because we're basically using the same data for testing the theory, which we've also used for generating the hypothesis in the first place. So that's a statistical point, and the content point is that context, I think, matters a lot here for understanding what it means to use guidance and to differentiate these agencies, and it would be nice to know more about this, in particular the statutory grants of power that enabled the agencies to do anything in the first place, and that's why I think it would be very nice to have comparative case studies in this paper, and I say that being a quant myself and always making fun of comparative studies, but I think in this particular case, that would be helpful. Yeah, thank you.
Thank you, Holger. Now to open the floor. Yeah.
My comment, I think, ties in with what Holger Sparman just said about comparative studies. I was wondering whether there might be 2 possibilities to extend the empirical basis of your paper. One might be comparative analysis, looking at agencies maybe in other jurisdictions. You might even think about constructing something like an agency independence index that you can use then to do comparative analysis and see what type of rulemaking emerges depending on a certain score in the agency independence index in various jurisdictions. The second thing I was thinking about is whether you can observe either in the US or in some other jurisdiction by way of a natural experiment that when there is a change in the degree of autonomy of an agency, so a change maybe in the agency independence score, let's say an agency gets a higher score, becomes more independent, whether then you can see a difference in the output, the regulatory output of the agency. So that might be another thing that you could look at.
Okay, so I'm going to do Horst and Holger at the same time. It would be nice if I could do comparative of other countries. I'm going to be language constricted in probably getting some information. That's an interesting point. Most agencies' design is fixed when they set up, so they don't really change them. The only thing that of these that we can say. And so the CPSC is true. They had, when they originally enacted, they had this huge amount of public participation. It was sort of an experiment for when they did standards. So they were allowed, the public was allowed to ask them to do rules, and they solicited third parties to draft the standards for them, and that was seen as very time-consuming. So they did change that, and they got rid of that. That's unusual. The only other thing is the SEC was given more in Dodd-Frank. It was given more abilities to use its for sanctions within its internal decision-making, and there's been this whole literature on they've increased the use of using ALJs as opposed to courts. But for things like, is it multi-structure commission, and the other, like the Datland-Revis criteria, they basically fix them when they're started. That's why most of the literature actually looks at the political conditions when an agency was created to make any sort of comparisons, because they're seen as fixed. But so there's only these, little bit of play that one could get on that. I think the reason why, although there are some studies, most studies actually in the political science literature look at one agency, right? And they don't look at many, right? But I'm trying to have some that are comparable. The problem is you wouldn't really want to compare a financial regulator maybe with the EPA, because given the nature, the substance of what they're regulating, you may need more rules versus guidance. It's just sort of hard to sort of say, are they apples versus oranges? So although it does limit in what I could compare, I was trying to find, and some people think that one shouldn't even compare these four, right? So you have to find some mix. There was one paper that actually looked at grants, because then that you can get a lot more agencies, because a lot of agencies give out grants to see if that was affected, although they use a different measure for independence. But the problem with that is, of course, grants, if I'm trying to get at something other than like the form of rulemaking, that's only one form of rulemaking, and it turns out independent commissions don't tend to give out grants. So it was mainly looking at executive branch. So there is an issue about how you can do in comparability, but I take, I accept sort of, I thank you for the comments and their valuable criticisms. On the 1 in 3, although there are 1 or 2 things that they have to do rules, there's a lot of flexibility, and they basically have self-executing statutes. My argument here is that you don't get the issue about judicial deference or whatever. So McGill has a good paper on this, claiming that these agencies are trading off, stricter rulemaking, more time, and getting deference. The problem is if no one ever challenges these other things, then it doesn't matter that the courts supposedly, I'm with you. I think a lot of literature thinks that it doesn't matter what the deference standard is, and they defer to them no matter what, right? But if no one's ever going to challenge the guidance, then it doesn't matter that they'd apply stricter scrutiny. And I think that's the issue with these agencies. But there are, on occasion, and it's what, I agree with you. The other issue here are all of these policy, right? So not every guidance is changing a policy, right? And that's what that's why I try to get rid of the ones that are insignificant. I'm trying to sort of hone in on things that look more like rules. But to give one of my other illustrations is they're not, when you talk about guidance, although you're saying it's not constraining freedom, but one of the CFPBs was, so one of the examples has to do with mortgage servicing agreements. There's a statute that prohibits kickbacks, right, of like paying someone to like when you're getting a mortgage and a kickback. But then the statute says, but if it's for bona fide services, then that's okay, right? And so the CFPB in its guidance, it wanted to treat everything as kickbacks. And the guidance then is so vague that you can't figure out, like, is there anything that would be valid under it? So it depends on, you're right, the statement of the guidance, but they don't always say, okay, now we know what's legal. Sometimes they make it so now we think everything is illegal, and so I think there's some issue about like how you deal with that. But obviously some are exactly as you describe and some aren't. But let's get more questions, please.
Yes.
So I've focused less on the CFPB, but have looked a fair amount at FSOC and other activities post-crisis. In many cases, the guidance comes from lawyers for prospective clients. That is to say, the statutes are very broad, the liability associated with them is vast, and in many cases, it's the lawyers who want guidance from the agency to narrow down the scope of enforcement discretion. And this goes really to Holger's point about a statute being self-enforcing. In many cases, I'm thinking about FSOC and its designation of systemically important financial institutions. All the guidance, in effect, narrows the scope of FSOC discretion. And it's an effort to, partially in response to lawyers for clients, to sort of know, what the range is. And so, and so there's an implicit assumption in the paper that guidance is an act of agency power extension as opposed to power limitation, and that, in effect, the demand, implicitly, the demand for guidance comes from consumer groups, whereas it may well be that the demand for the guidance comes from client groups. And so, in a way, it goes back a little bit to Holger's point about n equals 4, right? It's very hard to maybe draw the comparisons because of that and the particular environment in which the CFPB proceeds.
Yeah, so I take both of those points. I didn't think of demand as consumer. I thought I saw the demand as coming from agency staff wanting to regulate things or whatever. So, but I think this is certainly a valid point that's true of black letter rule. Why do we have black letter rules in our principles? Because when you're in a litigious society, the people who are going to be sued would like to get clarity. So I think those are certainly valid points. But then the question is, why wouldn't we might expect to see it across all of the agencies, right? And they're all engaged in guidance. So I'm trying to control for things. Now, this may just be an argument. You're saying, well, I should think more highly of guidance, right? Because maybe it's good to have guidance, and the CFPB then in this story, it's got a higher guidance than the others, and maybe that's good. So I have to sort of say, I'm in this from the sovereignty of the legislature versus the executive branch versus third parties view that I'm taking this paper. And so I think it is good to have things that even though Congress is dysfunctional, right? So we got a big problem, but in general, I think they're elected more frequently, right? So whatever you want to say about it. So I think I've always been a legislative centrist, so that's part of where I'm coming from in thinking about this structure. Right, and so the alternative would be, in just going back to your point about more agencies, is to bring in some cabinet. The only thing I could think of is maybe the OCC, but I don't really want to get into the prudential regulation, so I'd have to sort of cabin part of what they do with it. But I take the point. I have to sort of think about sort of putting how I put that into the paper. But my thought underlying this was that the agency can or cannot, doesn't respond. And maybe, I guess your idea would be to say what you might think the SEC is more responsive to wanting to do guidance for lawyers, or there's more lawyers involved in that than the others. But then, so how I shouldn't then I should find more guidance? Is there anything that would give me a hypothesis that I should find it, or do we think that should be related to what I'm looking at? This is just throwing it out as a question that we can talk about later, but I need to sort of figure out how that would be related.
Gerard?
Thanks.
Yeah, Roberta, I was wondering whether you could not engage in some more discussion of the strategic behavior of agencies, because they like to maximize their discretion. Now, from your paper, it looks like if they do nothing, they have maximum discretion. If they do rules and procedures, they have much less.
Yes.
In fact, it might be exactly the reverse. When you have rules and procedures that are pretty specific, what you can do to do a favor is do nothing, and that's not observable. And that gives you a lot of discretion. Whereas if you have done nothing to make a favor, you have to do something which is visible and can be contestable. So it might be nice to engage in some kind of game theoretical approach to see how those agencies behave and to maximize the utility.
So I think that's certainly fair, Gerard, to say that. So I'm just free riding off what political scientists talk about in the strategies, and I maybe should think more about that. But I certainly think sort of the standard trade-off is to say that rulemaking gives them less discretion than guidance, because we've got more give on that. It's not a final action. It doesn't go through this process. But I need to think a little bit more about that. All I'm trying to, there are some articles that, Conan Raz's got a paper where he argues his data suggests that they're not using guidance strategically. Right, so there are there's two papers that sort of looked at this, although they're not, necessarily looking at the same thing I'm looking at. They tried to say that it's not strategic versus it is strategic. There's a bunch of people, it's all over the map, so to speak, but I certainly take your point that I need to think more about that.
Yeah, so we'll just collect questions because there's 5 minutes.
That would be good. Thank you, Dan.
Up front, and Ron, and then Holger and Tobias. If you could just take them all at once.
Thank you. So just on the n equals 4 issue over here. I was wondering, maybe one thing you could possibly do to get greater variation is,
Okay.
in addition to looking across agencies, look within agencies over time. You would need to extend the sample out,
Yeah.
but the idea would be, the appropriations threat is going to vary with who controls Congress and who's running the agency. So you might expect to see, within the SEC, their NNC versus guidance ratio changes with those events.
So I do have some, why don't you take the questions? I have some time series
And
pictures here.
Ron?
If I can find my thing again. There I am.
Roberta, I enjoyed the paper, the talk very much.
Thank you.
But I want to just slightly reframe it. So there are two separate questions. One is, was Congress successful in giving the agency dramatically more protection from the political process than was normally the case? My recollection, but yours is going to be better, is that in fact was what Congress was trying to do, because I thought the general political process was biased against consumers, and they were building a moat around this. The effect of providing guidance is it made it that much harder for Congress Congress had to act, not the courts. So if I frame it that way, it strikes me that what the data shows, and I'm not a quant, so I'm persuaded, that Congress succeeded with this agency. Second question, which goes to your last comments, was it a very wise strategy for Congress, given the way the government works? But they're two different questions, and I think you did a really nice job of showing that an agency that was designed to be for Liz was designed pretty effectively for that purpose.
Holger?
I just wanted to add to the methodological point. I did not mean to suggest that you should expand your sample of agencies. I think the choice of these 4 agencies is wise for the reasons that you told us, which those are the agencies that you otherwise would expect to be most similar to the CFPB. All I wanted to say is that sometimes we just don't have the data to do it just with this data program or whatever, we need to do something else. And in other disciplines in political science, that's totally normal. And there are ways to doing it. We may more or less like them, but I think in this particular case, I'm inclined to think that it might be at least helpful to add to this a study along, for example, this discussion with Jeff. It would be nice to know. I mean, if you take at random 5 guidances from the SEC and 5 from the CFPB and 5 from the CFTC, what do they look like? What's the subject matter, and does it more look like there's actually something being carved out that the regulated entities care about, so it's actually deregulating? Or is it more the crap shot that you mentioned in your examples, where the agency just occupies the entire field and basically says everything's illegal? And that would I would think it would be extremely informative to know that.
And Tobias, Sven?
Thanks. Just a brief point on whether it's truly an indicator to use a consultative process that you are enhancing accountability in rulemaking, because it can be interpreted the other way around. If you think about the typical structure of these procedures, you get all sorts of comments which basically justify any kind of action that you're taking, because they're rarely this clear with regard to the recommendations that come out of them, that you bind your discretion by this. And I would probably ask if an agency is actually acting strategically, they might exploit precisely that in order to increase their discretion. So I'm not sure if this is truly an indicator for what you want to point out. And the second point that I just want to make briefly, Holger has mentioned they just might want to do it because otherwise they can't get things done. You may want to control for the staffing and the budget that these agencies have in order to just find out whether that's the case.
I did look at this. I have some data on their budgets. The CFPB has a very large budget, so it's not being constrained compared to the others, if you look at notice and comment, as well as staff. The CPSC has very little staff, and it's less important, but the CFPB was pretty big. The SEC was much bigger than all the others. right? If you look at staff stuff. I would say that what I meant by discretion was not what the comments say, but it's once you pass it, like you've got that rule. And so what people, at least in this literature, would say, guidance, since it's not considered a final rule, you can change it. To change a notice and comment, you have to go back through notice and comment. So it gives you less discretion. Independent, but so it's not saying about what the substance is. So I agree with you. The comments are not necessarily constraining them, right? And generally, the DC Circuit. So there's a weird, there's 3 cases where the DC Circuit, you get a certain set of judges, and they just knocked it out, saying you're not following cost benefit, and we didn't like the rules. But in general, that doesn't really happen. The CFTC, as a DC Circuit, you get different judges, or maybe they did a better job. They're not struck down. So I agree with you. The comments gives them discretion in the rule, but here the discretion meant that it's harder to change it, whereas if I do guidance, I can change that. It gives me more flexibility because I can more quickly, if I wanted to adapt it, I could adapt it. So I should have been a little clear on that. But I agree with what you're saying about the others. And I guess there's no time, so I will get back to other people.
Yeah, so
and
thanks
as I
to
said, comments are welcome from everyone else too. Thank you.